Good morning, everyone. I'm Amy Vasquez with Employers Association of New Jersey, and I want to welcome you all and thank you for joining us for today's session on workplace agreements, navigating the future of non-competes. As many of you are aware, and probably a good reason why many of you have tuned in today, the landscape around non-compete agreements has been shifting. There's been increased scrutiny at the federal level, there's potential legislative changes, so we thought this was a great opportunity to bring everyone up to speed on what's been going on and where we stand now. So our speakers for this morning are Brian Chabarek and Elizabeth Trottier, both attorneys with the law firm Davison, Eastman, Munoz, and Payon. Brian is a partner at the firm whose practice is devoted to labor and employment law, as well as the representation of public entities. And Elizabeth is counsel to the firm and a member of the firm's business and litigation group, specializing in employment law, business contracts, and litigation. So Brian and Elizabeth, welcome to you both. We are thrilled to have you with us today. You're clearly the people to be taking us through this topic. And just to our audience, you can submit your questions this morning using that Q&A area, which is on the right-hand side of your screen in the dashboard. And then we'll take a few minutes before we close out today to address any of the questions. So with that, Brian and Elizabeth, I turn the call over to you both.
Thank you so much, Amy. Good morning, everyone. It is our pleasure to be here today to talk about a hot topic for employment lawyers, that is non-compete agreements. And thank you to the EANJ for hosting this important topic. We are excited to speak to you today on what is an issue in the spotlight of recent non-compete agreements. Non-compete agreements, or restrictive covenants not to compete, have become increasingly widespread in recent years. According to the Federal Trade Commission, about 1 in 5 American workers, or roughly 30 million people, are currently subject to non-compete agreements. There's also a movement on both sides of the aisle, both on the part of employees as well as management, to obtain some clarity on what is permissible and what type of agreement would be enforceable or upheld by the courts. So this topic is relevant across industries at this time. We're going to split up our talk into 4 general sections today. First, we will talk about the basics, what non-compete agreements actually are and how they are generally used. Second, we will discuss the state of the law on non-competes in New Jersey. Third, we will discuss the latest developments with regard to the Federal Trade Commission's rule banning non-competes and the status of the litigation challenging the ban. And finally, we will touch upon the proposal for a uniform restrictive employment agreement, known as the UREAA, and how it could reshape restrictive covenants across industries. And ultimately, this talk will impact discussions you may be having internally about whether it's advisable or not to have lawyers draft these contracts for your employees and to have your employees sign such contracts. And then we'll open up questions at the end. Let's start by defining what a non-compete agreement actually is. A non-compete agreement, also known as a non-compete clause or restrictive covenant, is a type of restrictive covenant. It's a contract between an employer and an employee that prohibits the employee from working for a competitor or starting a competing business for a specific period of time and within a specific geographic area after the employee leaves the company. Employers use these types of agreements to ensure employees do not poach clients, trade secrets, customer relationships, or sensitive business information like pricing to competitors. Employees sign them because they want to remain employed. These agreements are usually signed in what we call the honeymoon stage of an employment relationship, when the employee is typically happy to be there and is not thinking of what happens at the breakup stage, which is separation. That is to say, either their resignation or the termination of their employment. When employees sign these types of agreements, they are agreeing not to use sensitive knowledge and relationships acquired during their employment after the employment relationship ends. Sometimes the information acquired is so highly particularized to an industry that immediately going and working for a competitor is wrought with problems for the employer. Non-competes are often seen in industries like technology, healthcare, finance. For example, a financial advisor might be asked to agree not to solicit their investment firm's clients or join a competing firm for a year after leaving their brokerage. A software developer might be asked to agree not to go work for a competitor company on a similar software development project. The example sometimes colloquially used is the recipe for Coca-Cola, which has been shrouded in media hype and intrigue. The company never patented their secret recipe. So how has it remained one of the most guarded trade secrets in the world for over 100 years? It is a closely held trade secret, and the few employees who have access to the formula have signed strict non-disclosure agreements and restrictive covenants, presumably so the employees would not go next door to Pepsi and make money off the recipe for Coca-Cola. That's the general premise behind non-competes and restrictive covenants, that companies have legitimate interests in protecting their trade secrets and confidential information so that it does not fall into a competitor's hands the day after that employee chooses to work elsewhere. However, critics argue that non-compete agreements can be overly broad, often restricting employees from pursuing better job opportunities or advancing their careers, particularly in industries where labor mobility is key to innovation. Critics also point out that workers sometimes don't even realize they are bound by such clauses. In some cases, people are asked to sign non-compete agreements when they first start a new job, often without fully understanding the potential implications of these clauses. So what exactly does a non-compete phrase or contract provision look like? I'm going to show you one just to give you some context and flavor of what this contract language actually might look like. It might look like something like this, and brace yourself for the next slide. There's a lot of dense legal text coming up. So this is an example of a non-compete provision. You'll see the highlighted sections are sections that an employer might adjust with regard to time frame. Time frame being the period of time that is expected for an employee not to provide competitive services to a competitor following their separation, which might be 6 months, 12 months, or a few years. You'll also see that the defined geography of where the employee is restricted from working might be a mileage radius from the employer's place of business or the geography the employer conducts its business. And it defines the scope of what the employee is expected not to disclose or use or participate in. I'm not going to linger on this language, but I wanted to give you some context to what these provisions sometimes look like. Obviously, the needs of each business vastly differ, and what companies may be trying to protect or avoid also vastly differs. The question clients always have with regard to non-compete agreements is it enforceable? Meaning, will a court of law uphold the terms of this private contract? Will the terms of such a contract survive a legal challenge? And the answer is it depends. Unless a private contract is illegal, it will be upheld by a New Jersey court. Courts do not like to substitute their own judgment for that of two contracting parties. However, where public interest is affected by the terms of a private contract, the courts may not necessarily uphold contract terms that could harm the public interest. I will go ahead and explain how New Jersey courts review non-compete agreements when they are being enforced, or what their enforceability is being challenged. So how does a New Jersey court treat non-compete agreements? Non-compete agreements in New Jersey are governed by both the common law, which is court decisions, and statutory laws, meaning laws passed by the legislature. There is no overarching blanket ban on non-competes by statute in New Jersey, and therefore the common law or court decisions are what provide us guidance. Just to give you a little historic context, prior to 1970 in New Jersey, non-compete agreements were void on their face, or void per se, because the restrictions on employees' ability to earn a living were considered too harsh. This meant that the court would simply strike the entire provision. They realized this hurt employers and created an all or nothing approach with unjust results. Everything changed, however, in 1970, when courts adopted a balancing test to determine enforceability, recognizing that employers had legitimate business interests to protect confidential information or trade secrets. The case that is often cited in New Jersey is Solari versus Malady, 55 EANJ 571. What happened in Solari? Solari was an Italian company that manufactured informational boards used in airports and railroad terminals. Malady was hired to work in a high executive position for a substantial salary for Solari to sell these boards. Malady signed a contract with the company promising to not promote or sell products similar to Solari or to divert any customers or business from them for a year following the termination of his employment, unless he received written consent from the company's board of directors. Unfortunately, Malady became unhappy working at Solari because he had to report to a new boss named Savali, and they had serious disagreements. And Malady thought he was being forced out. So he wrote to the boss's boss, the general manager of the parent company in Italy. Not surprisingly, Malady's employment was terminated. After Malady's termination, he then went to Italy and obtained a franchise for the sale of products in the United States that were competitive to Solari's. Not surprisingly, he was sued by Solari. In a dramatic departure from the pre-1970 void per se rule, the court in Solari versus Malady adopted a rule permitting partial enforcement of the non-compete to the extent reasonable under the circumstances. 1 year later, in Whitmire Brothers versus Doyle, 58 NJ 25, the court reaffirmed Solari's holding and established the modern fact-intensive three-pronged test in determining the enforceability of a non-compete provision. This became known as the Solari-Whitmire test. Under this test, non-compete agreements are generally enforceable as long as they meet three key criteria. One, that they protect a legitimate business interest of the employer. Two, that they impose no undue hardship on the employee. And three, that they're not injurious to the public. So first, the employer must show that the non-compete is protecting a legitimate business interest, such as trade secrets, confidential information, or customer relationships. A non-compete that is overly broad and does not protect such interests may be unenforceable. What's not protectable is matters of general knowledge in an industry, preventing competition, or restraining employees from exercising general skills or expertise developed by them during the course of employment. To constitute a trade secret, the court will consider several factors, including 1, the value of the information to the employer and its competitors, 2, the effort or resources expended in developing it, 3, the extent to which it is known outside of the industry. 4, the extent to which it is known by those involved in the business. 5, the efforts made to protect it from disclosure. And 6, the ease with which others may acquire or duplicate the information. Again, going back to the example of the recipe for Coca-Cola that has been guarded for over 100 years, that's undoubtedly a trade secret of the Coca-Cola company. Additionally, non-compete agreements cannot place what's called an undue hardship on the employee. The agreements have to be reasonable in terms of time, scope, and geography. Where there's no specific time limit, courts generally find that restrictions of 1 to 2 years are enforceable, though longer periods may be scrutinized more closely. Additionally, the geographic area covered by the non-compete must be reasonable and tailored to the needs of the employer. For instance, a nationwide restriction may be deemed unreasonable for a small local business. New Jersey courts generally adhere to this reasonableness standard, where they will balance the interests of the employer in protecting its business with the interests of the employee in pursuing their career. Courts tend to strike down non-competes that are too restrictive or overreaching. These are all fact-sensitive questions. If under the Solari-Whitmire test, the court believes that the non-compete is overly broad, the courts are permitted to do what's called blue pencil or modify the scope rather than invalidate the entire agreement. For example, if the court finds that a non-compete is overly broad in terms of its time or geographic restrictions, it may modify the agreement to make it more reasonable and enforceable. This doctrine is significant because it offers some flexibility to both employers and employees. It ensures that a non-compete agreement is not automatically voided if it contains an unreasonable term, as long as the court can modify it to be fair. But again, if you are leaving your agreement in the hands of a third-party judge to modify it to be fair, you never know what a judge will decide. The judge doesn't know the company outside of the case, and the judge doesn't know the employee. The judge will do what he or she thinks is reasonable under the circumstances presented to him or her. So the answer to the most frequently asked question of whether an agreement is enforceable is also the most frustrating answer to hear. It depends. But that is the truth. It depends on all of these factors, and it goes to the reasonableness and what is reasonable under those set of factual circumstances. Certain professions have special rules. For example, attorneys are prohibited by the ethics rules from entering into restrictive covenants of any scope. They are void on their face because they are considered injurious to the public. Clients should be able to choose their own lawyer, regardless of what their lawyer might have signed with an employer. Psychologists are similarly barred by their board of psychological examiners from entering into restrictive covenants because of the unique nature of the psychologist-patient relationship. The same is not true of doctors or accountants. Post-employment restrictive covenants in those cases are on a case-by-case basis to determine whether they are reasonable and enforceable.
With respect to the special rules and the distinction between what industry you are in and what capacity you are in, the courts will always look at the differences between what you are doing. For instance, doctors have a patient relationship. Patients have choice to go to which doctor to see. Lots and lots of physician practices do have non-compete agreements, but they are closely scrutinized by the courts because of patient choice to see the doctor. It's something that is so important, and that does affect the public interest. Those are scrutinized quite frequently. And believe it or not, one of the hot areas that I've had in litigation is veterinarians. Vets have lots and lots of non-competes. It's a highly competitive industry, and we are seeing them, but we are seeing them in the sense that some say, well, you can't compete within 25 miles. I've seen some that you can't compete in the county. I've seen some that say you can't compete in the entire state. But the courts will look at the differences between the doctor-patient relationship, or is it a pharmaceutical company that is actually protecting their trade secrets? And towards the end, we'll talk about some real-world scenarios we've had, because I've had quite a bit of litigation involving non-competes, but I just wanted to chime in on that.
Thank you. Thanks, Brian. Okay. Although there is little statutory guidance in New Jersey on non-competes, one significant recent development was the New Jersey Domestic Workers Bill of Rights Act, passed in 2023, made effective July 2024. This act prohibits restrictive employment agreements for domestic workers providing domestic services. Domestic workers are defined as workers who provide in-home childcare, home cleaning, home care, cooking, gardening, other household occupations. The statute recognizes that many domestic workers are women, immigrants, persons of color who work in or about private homes, isolated from other workers. The law provides a private right of action in court against employers and hiring entities. In other words, they can sue, and if they win, they can seek attorney fees and costs against the employer in addition to other remedies. These types of employees, who often have limited access to proprietary information, were effectively being prevented from finding new jobs within their communities or advancing their careers, and the law provides that these workers are no longer subject to non-compete agreements, providing them with greater freedom and mobility in the workforce. This move reflects a growing national trend of limiting non-compete agreements for lower wage workers who are often the least able to negotiate the terms of their contracts. It also shows New Jersey's recognition of the need for greater fairness in the labor market, particularly in industries where workers have limited bargaining power. Public opinion on non-competes is also shifting. As more workers become aware of their rights and the potential harms of non-compete agreements, there's been increasing advocacy for stronger restrictions on these types of clauses. Workers' rights organizations have called for bans on non-competes in certain industries and for the adoption of more employee-friendly policies in New Jersey. And I'm going to turn it over to Brian now to discuss what happened in 2024, which some thought would be a sea change in the law with regard to the Federal Trade Commission.
Okay, so I am sure that many of you saw all the articles that were written about the issuance of the Federal Trade Commission's nationwide ban or attempted ban on non-compete agreements. And I can't tell you how many phone calls we received last summer as to what actions employers should do because of all of the requirements, the tight timeframes and consequences that were built into the FTC ban, which ultimately was challenged in court. So essentially, the Federal Trade Commission, as you know, is an agency of the US government whose principal mission is the enforcement of antitrust law and the promotion of consumer protection from deceptive and unfair business practices. And they passed a new rule that they had been working on for some time. The FTC rule banned non-compete clauses, and it was first proposed in January of 2023. The idea behind the proposed rule was simple. The FTC believed that non-compete clauses are harmful to workers and competition, reduce wages and career mobility for millions of people. The FTC's rule proposed to make non-compete clauses illegal across most industries and employment situations, arguing that these clauses suppress wages, hinder innovation, and limit workers' ability to switch jobs or start their own businesses. After the FTC proposed the rule in January 2023, it opened it up for a period of public comment, which lasted until April 2023. During this comment period, the Commission received over 16,000 responses, which ranged from individuals to large corporations who each had different perspectives on the issue. The vast majority of comments from workers, labor organizations, and consumer advocates were obviously in favor of banning non-competes. They cited to the harmful impacts that these agreements have on a worker's ability to change jobs, earn higher wages, and contribute to economic growth. On the other hand, many businesses, particularly those in tech, finance, and other intellectual property-heavy industries, opposed the rule. They argued that non-compete clauses are necessary to protect trade secrets, proprietary knowledge, and prevent unfair competition. After reviewing these comments, the FTC moved forward with a revised version of the rule, and the final rule was announced in April 2024, which included several key points. First, it was a broad ban. Non-compete clauses would be banned for most workers, with exceptions for a very limited number of cases. It superseded all contrary state law. It applied to all workers, including independent contractors who are not employees, externs, interns, volunteers who provide services to clients or customers. It also had sweeping effects because it had what's called retroactive application. It applied to not only new non-competes, but also to any existing agreements. This meant that employers would be required to inform workers of the ban and cease enforcing non-compete agreements or clauses, even if they were signed several years ago and all the parties relied on them. The rule even provided model language for this mandatory notice, which was the reason we were getting so many calls because of the effective date and the deadlines. The effective date was September 4, 2024, and by that time, the employer would have had to have notified anyone who had a non-compete that they're not enforceable. The certain limited exceptions where non-compete agreements would still be allowed pursuant to the FTC ban included very high-ranking senior executives or those with significant access to sensitive business information. The FTC defined a senior executive as a worker who earned more than $151,000 a year and was in a policy making position. With that, they were only allowed to enforce existing non-competes for senior executives that were in effect, the ones that could remain enforced that had already been signed. But employers were still banned from entering into or attempting to enforce any non-new competes, even if it was a highly compensated or senior executive. The FTC was mindful to say this does not categorically ban non-disclosure agreements or non-solicitation agreements. Non-disclosure agreements usually protect confidential information. Non-solicitation agreements protect a client's customer base or other employees, so that when an employee leaves another employer, they don't poach their customers that they worked for years and years to develop, or they don't poach their employees. The courts do look more closely and scrutinize non-compete agreements more than non-solicitation agreements, because non-solicitation agreements are protecting customer-client information of the client and not necessarily banning someone from going to work for a competitor, but not allowing them to steal their customers or clients who they worked so hard to develop over the years. Violations of that FTC ban exposed employers to fines, penalties, and what's called injunctive relief, meaning that the court could take immediate action. As expected, litigation ensued in various jurisdictions, and litigation was filed within days of the enactment of the FTC ban. The first case was ATS Tree Services versus the Federal Trade Commission that was in federal court in the Eastern District of Pennsylvania. ATS Tree Service was a small tree care company in Bucks County, Pennsylvania that only had 12 employees. The company required its 12 employees to sign non-compete agreements, which restricted them from working with competitors for a period of 1 year after leaving the company, within the geographic area in which the employee worked while at ATS. I will reserve comment on whether it was necessary to non-compete for tree removal workers as opposed to other highly sensitive information like pharmaceutical companies. And the courts will take a look at that, and that probably played a factor in the court's decision here. Following the passage of the FTC rule banning non-competes, ATS Tree Services sued the FTC in the United District Court for the Eastern District of Pennsylvania. ATS argued that the company would suffer what is called irreparable harm if the FTC rule banning non-competes were to go into effect in September of 2024, and argued that the FTC lacked authority to issue the rule. That is, most of the challenges that were in court were that the FTC, as an agency, did not have authority to issue those rules. Those took an act of Congress to do that, to set the law. ATS sought a stay of the FTC's effective date, meaning that until the court made a final determination, it would not become effective September 4th, 2024. The Eastern District of Pennsylvania denied that injunction and upheld the FTC ban in July of 2024. The plaintiff employer then abandoned their case and dismissed it, and there were no further appeals of that litigation. But lo and behold, there were two other decisions. The second case, which was known as the Properties of Villages versus the Federal Trade Commission, came out of the Middle District of Florida and did the exact opposite of what the federal court in Pennsylvania did. While Pennsylvania upheld the ban on non-competes, Florida enjoined the FTC from enforcing that rule on August 15, 2024. In a decision that came straight from the bench because the court was aware that the rule was going into effect less than 3 weeks later, and any written decision would take substantially longer, the court found that the FTC ban did not apply to the properties of the villages or the plaintiff that challenged that action. To obtain an injunction or a court order stopping something from happening, in this case, the FTC rule banning non-competes from going into effect, a litigant has to show several facts. That is, factors: a likelihood of success on the merits. Here, that the FTC lacked the authority to issue the rule. That is, it took an act of Congress. It wasn't something that the FTC was charged with. 2, risk of irreparable harm, meaning that the harm cannot be addressed by monetary damages later on. 3, a weighing of the harms involved, that the harm that the company would suffer clearly outweighs the public interest in eliminating non-competes at that time. 4, that there was a settled legal right, that the law is well established to support the position that was taken by the company to enforce their non-compete agreements. Interestingly, the Florida court recognized that the impact of the FTC ban on employers would be significant. The court mentioned that employers would be paying $400 to $488 billion more in wages, and that there would be a significant transfer of value from employers to employees and a huge economic impact on the American economy if the rule were to go into effect. The Florida court found that the plaintiff employer showed a substantial likelihood of prevailing on its claim that the FTC rule exceeded its authority. The court further found that the significant business disruption that would be caused by having to comply with this rule constituted irreparable harm. Finally, the court found that the FTC was not operating within the bounds of its statutory authority, and they will not be harmed by maintaining what is known as the status quo until the validity of the final rule was reached. The Federal Trade Commission then appealed that ruling to the 11th Circuit Court of Appeals. That appeal is now being held in abeyance, meaning that it is stayed and the court is not going to take any action until at least July 18, 2025. That is because of the change in administration, as the chair of the FTC had asked for additional time to consider whether they wish to continue defending the rule and the issuance of the FTC ban. A third case, known as Ryan LLC versus Federal Trade Commission, came out of the Northern District of Texas. And like Florida, Texas also did the opposite of what the federal court in Pennsylvania did. On August 20th, 2024, the Northern District of Texas granted summary judgment to the plaintiff, employer, and enjoined the FTC from implementing and enforcing its rule. The Texas court set aside the rule and ordered that the FTC cannot enforce the rule. The Texas court held that the FTC exceeded its statutory authority in implementing the rule, that Congress did not give the FTC authority to make substantive rules about methods of competition. The ambit of the FTC's authority is limited to deceptive practices, not methods of competition. Again, the FTC appealed to the Fifth Circuit Court of Appeals because this was in Texas, and the case does remain stayed at this point until July 12, 2025, for the same reason. That is, the FTC commissioner, with the change in administration, is now evaluating whether to proceed with the appeal. So at this time, it's an unknown as to whether the FTC will ever go into effect. So what does this mean for employers? Again, countless calls that we've received, and right now it's status quo. Your current non-compete agreements are still effective. They're still in force. They're still subject to the reasonableness requirements that have been the law in New Jersey for some time. And until advised otherwise, employers should remain with the status quo with the agreements, but still have to pay particular attention to what's going to happen with these matters, particularly in the summer of 2025. The appeals, that is, have not been withdrawn yet. And so it's unclear what will happen next, and we take a wait and see approach, but we have to be mindful and be proactive in seeing what happens, especially with all the requirements that were placed on employers if the rule were to go into effect. So what should employers with non-compete agreements do? As I said, they should be proactive, review your current agreements to ensure that your non-compete, non-solicitation agreements are reasonable. That is, given the current climate that we see, not only through the FTC ban, but we've seen throughout the United States. We've seen in New Jersey. There seems to be a marked effort to either ban or limit non-compete agreements. And again, stay up to date with respect to any developments with current court action, and certainly consult with counsel because of the fast-moving changes that could occur. The FTC was also mindful when they issued their rulemaking decisions, and their fact sheet on the bases and some of their analysis is still on their website. But they were mindful of the fact that although there's a ban on non-competes, it's not a ban on non-solicitation agreements to protect clients, customers, or poaching employees. It's not a ban on non-disclosure agreements protecting confidential information, but they were also particularly mindful that you're not going to convert a non-compete into a non-solicitation agreement. So to be very mindful that you're not basically just hiding it in a non-solicitation agreement, because that's not going to happen if the ban was enforceable. And another alternative to protecting trade secrets that hasn't been talked about a lot, and is the trade secret laws that protect proprietary and sensitive information. There's the Federal Defend Trade Secrets Act, and there's the New Jersey Trade Secrets Act. If trade secrets get misappropriated, the Trade Secrets Acts are to prevent the unauthorized disclosure of sensitive information, which they've defined to include design, formulas, programs, techniques that companies use. The employer has to take basic precautions to protect those trade secrets, but there are laws in place to address that. And like any law, there's exceptions. There's whistleblower immunity. If someone is taking that information to blow the whistle and say that there's illegal conduct occurring or there's a violation of OSHA or whatnot, they still would be protected as a whistleblower, but they wouldn't be protected from stealing companies' trade secrets and turning it over to their new employer. So as I said, the key here is to just be mindful and make sure that your agreements are narrowly tailored to protect your company interest. You don't want to see an agreement, which I've seen, where your non-compete is effective not only in the markets that the employee worked in, but also in the United States, and for good measure in the entire world, which I've seen. So You want to be mindful of that as well, and just pay particular attention to that. But now is also a good time to take stock of any non-compete agreements that you have in effect, just because of the current climate we're in. And with that, I'll turn it back over to Elizabeth.
Okay. So business community and employee advocate groups have been frustrated with both the lack of clarity within most states on when non-competes are enforceable or unenforceable, and with the variety of diversified approaches among the states. State to state and within state variations make it difficult for employers who do business across the country to adopt consistent policies for the various jurisdictions, and for workers to know their rights and obligations under a non-compete. The same is true of employees who need predictability in our increasingly mobile society. This movement toward trying to obtain some form of national consensus regarding non-competes is also seen with the Uniform Law Commission's proposal for a Uniform Restrictive Employment Agreement Act. The Uniform Law Commission is a nationwide nonprofit group made up of lawyers, judges, legislators, legislative staff, and law professors who have been appointed by their states to research, draft, and promote enactment of uniform law where it may be desirable or practical. A committee representing the commission was formed, and in 2021 they finalized and approved the UREAA because of the movement developing across the political spectrum that reform is necessary in this field. So what does the UREAA provide for? It's very similar to New Jersey's Solari-Whitmire test. A core tenet of the Act provides that a restrictive employment agreement is prohibited and unenforceable unless it is reasonable. This reasonableness inquiry considers all the facts and generally requires a balancing of the employer's interest, the worker's interest, and the public interest. In cost-benefit terms, this inquiry asks whether the benefits of the agreement outweigh the harms. The requirement that the agreement be narrowly tailored in duration, geographical area, and scope of actual competition tracks closely with New Jersey's reasonableness inquiry. So where does it differ from New Jersey law? Unlike existing New Jersey law, the UREAA imposes a requirement that a less restrictive means, such as a non-solicitation or no business agreement, must be employed if it is adequate to protect the legitimate protectable business interest. No such requirement exists in New Jersey. The statute creates a bright line time limit for specific protectable interests that cannot be exceeded. These requirements are 5 years in the context of the sale or creation of a business in which the worker is a substantial owner, and 1 year if the legitimate protectable interest is a trade secret or an ongoing client or customer relationship. No such specific temporal requirement exists in New Jersey. Rather, the court will make a fact-specific determination on whether the time duration is reasonable in the circumstances. Unfortunately, the UREAA has gained little to no traction since 2021, and it has not been adopted in any state. So, in conclusion, your key takeaways today should be that the FTC ban has been struck down. The FTC appeals are currently stayed. The FTC may abandon their appeals altogether, and non-competes will be handled in the same way that they've been handled by New Jersey courts the last 50 years with the 3-part Solari-Whitmire test. That's not to say, however, that non-compete agreements in New Jersey aren't facing increased scrutiny with legal, legislative, and judicial developments possibly on the horizon, as Brian mentioned. While non-competes continue to be enforceable in certain circumstances, There are growing efforts to make them fairer and more transparent, especially for lower wage workers. And as the law in this area continues to evolve, it's important for both businesses and workers to stay informed and engaged with the process, because its final outcome will impact how we think about job mobility, competition, and innovation for years to come.
Now, I mentioned some real-world scenarios since we have dealt with, unfortunately, litigation in this realm. Although we always say our goal as attorneys is to keep our clients out of court, it's inevitable you're going to get there at certain points. And we all know that after an employee leaves is when the employer learns of all the bad acts or bad actions that that employee did. That's why it's always advisable to have in your handbook or policy a specific section that sets forth that you have no expectation of privacy in your email, because guess what? When you leave and we image or go through your computer, we now find that you were downloading information, you were sending information to your personal email address. We can even see if you went in under your personal email address. And as I said, the employer usually learns of these actions after the employee did so. And in a certain case, an employer left and downloaded what was the secret sauce, the pricing lists, some of the methods and means that really allowed this employer to be a leader in that market. They learned of all this after the client left. The advice to the employer is don't sit on it, don't delay it for 6 months, because in order to go to court, you need to show irreparable harm and you need to take immediate and swift action. If you delay it, then it's much harder for you to show that you have been harmed. So we've had actions in that regard where the employer didn't do anything about it for 6 months, 8 months at a time, and it's going to be much harder for an employer to do that rather than if you go, say, within the first 30 days of learning that information. We've had situations where the employer obviously was paying attention and realized that one of their employees downloaded their entire database over the course of a weekend, including every tax return. It was every tax return, everything everything they had for client information. And when confronted, the employee said, "Oh, I thought it was just an update to the system we use." And as I mentioned, just make sure that those agreements are narrowly tailored, because we have had circumstances where the agreements say the entire United States. It really, really has to be in the areas that that employee worked in, because you are affecting an employee's ability to make a living. It's also very difficult to just throw in, well, prospective customers, prospective clients. What is that? How do you define that? And also one tip for employers, when you do have an employee coming on board and you know it's a highly sensitive area, they usually will acknowledge they're not bound or restricted in taking on this new employment by another restrictive covenant or non-compete, because guess what? If they're violating it, you as the new employer are going to get sued in addition to the employee. So that's one other tip that can be used to try to insulate yourself if a litigation is instituted. But as we said, the key is to just have them narrowly tailored and suited for its use. And with that, I think if we have any questions, we certainly have time to do that.
So great job to you both. And thank you for this, because this is clearly a very complex topic, and you both did a great job of breaking it down and making it digestible to us non-lawyers in the room. So a few questions. Can the New Jersey law limit the employer's use of non-compete agreements with respect to employees working in other states? So would a New Jersey court would they evaluate that type of agreement?
I would say that yes, but it also depends. I hate to use the lawyer terms, it depends. But if that company has frequent customers and clients in, say, Delaware, New York, wherever it is, absolutely, because there's lots and lots of employers in New Jersey who do a lot of business out of state. So, and if you have a salesman who's constantly, say, flying to Chicago or going here, yes, you can limit it, but I would highly advise not to limit it, to the entire United States, and keep it to the area where that actual employee works or has customers or clients, and ones that they worked on. If the employer has clients or customers in California, this employee has no idea who they are and never touched them, it's going to be harder to enforce that. But if they're constantly flying to Chicago or whatever, and yes, you can limit that. But courts are always going to look at the industry. And one thing I neglected to say too, pharmaceutical companies, a lot of times for their high-level employees, will build in a 1 or 2 year non-compete. Once you start getting beyond 2 years, the courts really start scrutinizing them. But they will pay you for that 1 year period, because maybe you develop the formula. It's going to be much harder for the employee to say that they are harmed because they're getting paid for a year to sit out. So that's another thing that we neglected to mention. But hopefully that answered the question. Unless Liz...
Yeah, and just to add, it's advisable to have a lawyer look at your agreements, because the contract should contain something called a choice of law provision, as well as a venue selection, so that, if you do have an out-of-state employee, or you have a New Jersey employee doing business outside of New Jersey, that there is some clarity on where the dispute will be heard, and to ensure that you're in the venue you want to be in. So again, emphasizing the importance of making sure a lawyer eyeballs these agreements that you're using.
That's great. That's great. So I've heard you both say this morning, narrowly tailored, right? So if employers decide to continue with their agreements, is there a specific period of time that's generally considered acceptable? And I guess to sort of, piggyback off of that, when courts are looking at this determination as to what is reasonable when it comes to duration or geographic scope, isn't that somewhat subjective? So maybe the employer goes ahead with what they think is reasonable, and then, it's going to be in the court's hands as to determine whether it is or it isn't, I guess.
I usually advise 1 year seems to be the norm or tolerance of acceptance. Certain industries, pharmaceutical companies, maybe it could be 2 years, where you're dealing with the scientists or people who develop the formula. 1 year seems to be the breaking point in my experience with the courts. And I keep saying it really is very fact specific on these agreements, and every judge will tell you that. But yes, 1 year seems to be the standard limit, but there is no set defined standard like there was proposed, I think, in the UREAA proposal.
Gotcha.
Yeah, and you also need to be mindful too that, what's the time frame you've had this employee at the company? Did you only employ this person for 1 week, and you're looking to enforce a 2-year non-compete? So the facts, again, it's all circumstantial, and it's dependent on the set of circumstances.
Right, and when we talked about that case that came out of Pennsylvania, we talk about bad facts make bad law. It's going to be hard to enforce a non-compete against people who are cutting down trees.
Right.
It has to be a reason that, you have access to the secret sauce. You have access to the customer. You're dealing with the customers. You're getting new clients and customers in, and they're not, ones that you could, as an employee, have a carve out when you join and say, well, wait a minute, these are ones that I brought in a non-solicited. So I could take them with me. You can always have that carve out, but the tolerance with the courts, at least from what I've seen, always seems to be the 1 year.
Okay. So we're sort of up against the clock, but I'll end it with one last question. What is the process to seek enforcement of a non-compete clause in court?
Well, first and foremost, setting aside that you usually send out what's called the cease and desist letter to try to resolve it outside of court immediately if you can, because court is expensive. You go to what's called the Chancery Court. The Chancery Court is a court of equity that moves much faster than the Law Division, which deals with monetary damages. And it's Chancery because you're seeking an immediate injunction against that employee harming your employer and from doing anything with the information that he obtained. Chancery courts do move quickly. You file what's called an order to show cause, which seeks immediate temporary relief, but you have to show what's called immediate irreparable harm, and the court can issue a preliminary injunction, and then you have a full-blown hearing later on for a permanent injunction. But Chancery judges, the Chancery courts in the state of New Jersey are very well versed in dealing with these applications of non-competes. They see them all the time. So, but the process or procedure is to file what's called an order to show cause seeking immediate temporary relief. You'll usually get an order from the court within 3 days, setting all the deadlines for a hearing. If you're the employer and you're actually can prove monetary damages, a lot of times the Chancery court won't, they won't necessarily deal with the monetary damage. They'll send that over to the law division, because Chancery is a court of equity that's dealing with the immediate irreparable harm that could occur and could put a stop to it. If there's anything to add. I'm trying to do it without being too lawyerly.
Well, and I guess at that point you'd have your lawyer, the employer would have their lawyers involved at that point anyway, certainly.
Right. But you got to move quickly. Like I said, you can't have that situation where the employer waited about 6 months and then went to court. Well, now how do you show immediate irreparable harm if you sat on this for so much time?
Right. That makes sense. That makes sense. Well, Brian and Elizabeth, I want to extend our thanks to both of you for sharing your knowledge this morning. I know that I am walking away with a couple of great takeaways. To all of you that are on the line, Brian and Elizabeth both have their emails on the screen. I'm sure they would welcome any questions, and you know that you can always reach out to EANJ with any questions that you have as well. So thank you again to you both, and I hope everyone has a really great rest of your day.
Thank you.
Thanks.